everybody. Welcome to this Garden Court webinar on the Nationality and Borders Act and new immigration rules as they relate to asylum procedure. Today, we've got an hour to look at the way in which refugees are to be treated split into two categories under the Act, and then also to look at how that is received into the new immigration rules, which have been promulgated to accompany the changes in the legislation, and also to look at how that impacts upon family reunion rules as well. We have today two of us speaking, Ava Durr, who's going to speak first, and then I will carry on afterwards. So without more ado, I'm going to hand over to Ava, and she's going to present the first part of the presentation.
Thank you, Adrian. I think now you should be able to see my screen share and my slides. So as Adrian said, I'm going to start us off today, and I will first be speaking really about the new immigration rules in relation to asylum, but that of course is closely linked to the coming into force of some of the major provisions in the Nationality and Borders Act 2022. So what this talk is really aimed at is to provide an overview of some of the new immigration rules relating to asylum. And then Adrian will take over, and there's some cross-section between our subjects talking about the new private and family life provisions. And then secondly, I'll take a little bit of a closer look at the differential treatment of refugees under these new provisions. So the first point really is obvious, and you will have already heard it or engaged with this, of course. But the Nationality and Borders Act makes, of course, a large number of changes to the asylum system in the UK. And
Hello.
Oh, I could just hear someone. Okay, I think it's fine. Now, to implement this reformed asylum system, the Secretary of State has laid a statement of changes that you can access through the link there on the 11th of May 2022, and that really introduced the new immigration rules on asylum. Now, it's important to say in the beginning that most of these changes will come into force on the 28th of June, so next week, in 5 days, on Tuesday. And the relevant thing to look at is that anyone who registered their claim, or even those who were awaiting an appointment to register their claim before this date, so before the 28th of June 2022, will be considered under the current rules, and only those who commenced this process from the 28th of June onwards will be considered under these new set of immigration rules and statutory provisions. Now, this is really a very broad overview of the changes that have been made to Part 11 of the rules. And anyone who really wants to get their head around all the changes that's been made or that will be made to the immigration rules should probably look first at the explanatory memorandum to the statement of changes, because that's quite helpful and sets out in detail the changes that are being made. So I'm just going to here give a very broad overview of some of the main changes that will be made on the 28th of June. Now, the first change I want to talk about is revocation. Now, there's a small but important change in that now caseworkers must, rather than shall, revoke refugee status where a person is convicted of a particular serious crime. And that's set out in paragraph 338A. And of course, important, I haven't set it out here on the slides, but that the definition of particularly serious crime is changing, or has changed, sorry, will change next week because of Section 38 of the Nationality and Borders Act. So what that means is that now a particularly serious crime is defined as where someone received a sentence of 12 months rather than the current 2 years. Now, the second change I want to talk about is the inadmissibility provisions. Yeah, those of you who attended our seminar on Monday will have heard quite a lot about the inadmissibility provisions and how that is currently impacting, the whole policy of the Secretary of State to seek to transfer people to Rwanda. And really, I don't want to go into detail in the context of this session into this, because you may just want to watch the recording of Monday's seminar to gain more of an insight as to what's happening. But in short, paragraphs 345A to C currently set out in the immigration rules. So these are the general inadmissibility provisions, and then also 326C to F, which relate to inadmissibility of EU asylum claims, or EU asylum applications. They will all be removed. And the reason for these sections to be removed, or the paragraphs to be removed, is that they are now included in primary legislation in the Nationality and Borders Act. Now, the next point, and this is something that I will talk about in more detail, as said, is the differential treatment and the implementation of the two-tier refugee system. And all the new rules relating to that change are set out at paragraphs 339 QA to QE of the immigration rules that come into force next week. Now, my last point, by way of overview, is the family reunion, or the family reunion provisions. I don't actually intend to say anything about it, because Adrian is going to talk about that in the second part of this seminar. Now, looking further into the two-tier refugee system. And I'll start by talking about the definition of what a group 1 and what a group 2 refugee is. Now, important to figure this out, and important to establish for your particular client whether they'll fall within a group 1 refugee, or perhaps more likely in a group 2 refugee. You have to look at Section 12 of the Nationality and Borders Act. So I've replicated here on the slide Section 12(1)(2)(3), although you would also look at Section 4. But really what I wanted to highlight here is to say that this sets out, especially Section 12(2) and 3, sets out the definition of a group 1 refugee. And in order, let's say group 1 refugees are what you want your client to be, because that's the much better status. So what you want to try and do is argue, if possible, that your client meets the 3 requirements that are set out in Section 12(2) and 3. So the 3 requirements, I've kind of underlined them here in the provision itself. But the 3 requirements are that the person came directly from the country where their life or freedom was threatened. Now, this provision, it's really important that you read this provision together with Section 37 of the Act, which kind of redefines this notion of coming directly. So really the question is, and I'll come back to that a little bit later on, the question is whether a person could have reasonably claimed asylum in another country that they've passed on their journey to the UK. So again, this provision really aims at targeting those who had a chance to claim asylum elsewhere, but instead chose to come to the UK and really penalize them. Now, the second requirement then is whether they've presented themselves without delay. That's set out at 12.2b. And then thirdly is when they entered the UK, or when they were present in the UK unlawfully, they have to show a good cause for this unlawful entry or presence. Now, having defined what a group 1 or group 2 refugee is, so I should say anyone who doesn't meet any of these 3 requirements is therefore a group 2 refugee. Now, what difference does it actually make if you're classified as a group 1 or group 2 refugee? Now, in order to find the provisions for that in the Nationality and Borders Act, you have to look at section 12.5, which provides the Secretary of State with different powers as to how to differentiate between group 1 and group 2 refugees. So here it says, an immigration officer or the Secretary of State may treat group 1 and group 2 refugees differently in respect of the following 4 issues: the length of any period of leave to enter or remain granted to the refugee, the requirements that the refugee must meet to be granted indefinite leave to remain. Then there are also provisions or powers to curtail or decrease access to benefits. So I've just, or we've spoken about this provision briefly also with Adrian. And it's interesting, while these powers exist, it seems as though they've not yet been used by the Secretary of State. So it looks as though both class or group 1 and group 2 refugees have recourse to public funds for the time being. But that's certainly something that could change. And then D, the 4th provision, is the family reunion provisions. And these can be different depending on whether a refugee is a group 1 or group 2 refugee. Now, how does that translate into the immigration rules? So what powers has the Secretary of State actually used already? Now, to get an answer to that question, you have to go to paragraph 339QA of the immigration rules that come into force next week. And here it really sets out what the Secretary of State has done. And I think my next slide is a little bit easier to understand it, because that is kind of an overview and a summary of the differential treatment between group 1 and group 2 refugees. So there are three main differences. The first one is that a group 1 refugee is granted, as currently every refugee is granted 5 years of leave to remain. Now, if the person is classified as a group 2 refugee, they're only granted what's called temporary refugee permission, which is a 30 months, so a 2.5 years grant of leave to remain. Now, the important thing here to remember, and that's set out in the rules, that this is somewhat qualified by the phrase, unless exceptional circumstances apply. So I'll come on to what that may mean for your practice, but that's a really important caveat to bear in mind. Now, the second difference in treatment then is that group 1 refugees can get settlement, so ILR, after 5 years under the usual appendix settlement protection, which, by the way, that has also changed slightly in this new set of immigration rules, just in line with these general changes. But yeah, they can get settlement after 5 years. Now, group 2 refugees can only get settlement after 10 years continuous lawful residence, so under the usual paragraph 276b of the immigration rules. But really there is no other settlement provision or ILR provision for Group 2 refugees. And then thirdly, again, what Adrian's going to talk about more is that Group 1 refugees have full refugee family reunion rights, whereas Group 2 refugees, their rights to family reunion are more restricted. Now, humanitarian protection, that's another very important change to the rules. And I believe Adrian is also going to touch upon this and talk about this. But this is really important. People who are granted humanitarian protection will also now only receive a 30 months grant of leave to remain. And that also has the same knock-on effect as for Class 2 refugees on their ability to get ILR. So they also need to be under the 10 years continuous lawful residence provision rather than under the 5-year settlement protection route. And that really is irrespective of whether they are in Group 1 or in Group 2. So the relevant paragraph in the new immigration rules is 339 QB, and it's set out here. So that's another really, really important change. And that leads me on to my last slide, where I tried to set out really ways in which you may want to deal with these changes, or some thoughts on how practitioners may want to deal with these changes. So there are really 3 tips, as you like, that I set out here. Now, firstly, it's really, really important that if you're dealing with an asylum claim, that you take instructions on why the person, so first of all, on their journey to the UK, and then why the person did not claim asylum in another safe third country. And then you'll want to argue, again, this is to try and argue that your client may be a Group 1 refugee, although it will be extremely difficult. You'll want to argue that the person, or you'll have to argue that a person came directly from a country where their life or freedom was threatened to the UK. So you should ask questions like, why did you not claim asylum in any of the other safe third countries that you traveled through? Were you able to access the asylum procedures? If not, why not? And then really show on the individual facts of your case, where possible, that it was not reasonable to expect this person to claim asylum elsewhere. So it could be that someone, for example, was under the control of an agent, that they have very specific vulnerabilities which inhibited their ability to claim asylum elsewhere. So, for example, mental health issues, which will, of course, require medical evidence. And then maybe also look at difficulties in accessing asylum procedures in certain countries. So depending on what instructions you get, you may want to look into accessibility to the asylum procedures elsewhere. But I suspect that this will at least require, an expert report or evidence from, for example, charities that are operating in the specific country. Now, secondly, then, if you can't argue that a person meets the definition of a Group 1 refugee, then you really take instructions, or in addition, take instructions on this exceptional circumstances provision in the rules, why a person should nevertheless be granted 5 years leave to remain. It's another really important piece of advice for practice, and it's good to get any of these representations in as early as possible and as full as possible and evidenced as possible. Now, a third major change that I briefly spoke about is the changes to the humanitarian protection provisions. That really means that more attention needs to be focused on arguing that a person does fall within the definition of a refugee. Until now, it didn't matter as much whether a person was granted humanitarian protection or for refugee status. But now it's really, really important to focus, for example, on establishing that a person's view of persecution is on account of one of the 5 convention reasons. Okay, so that's really my whistle-stop tour through some of the changes, not all of them, but some of the changes to the immigration rules in light of the new provisions in the Nationality and Borders Act. Adrian, I'll hand over.
Thank you.
To you.
Thank you for that extremely interesting tour through Group 1 and Group 2 refugees. I'm just going to share my screen, I hope, and we will kick off with the second part of it, which is to look at family reunion provisions as they're adjusted in the rules. So clearly, the whole purpose of Section 12 is to divide people and according to their method of arrival, and then to punish those whose method of arrival is considered to merit it under the legislation. Of course, we're dealing with people who have suffered persecution, suffered difficulties on their journeys to the UK, very vulnerable people, and the consequences are that it plays out in the punishment, if you like, is an increasing, is that their lives in the UK will remain precarious, not only as regards their status, if they don't have access to settlement, but also as regards their ability to bring their family members to rejoin them. And that whether that sends any message or any signal to people coming is a moot point. It shouldn't, and it's unlikely that it will in any event. But when you have a look as we're going to tour through the procedures as they exist for family reunion, you'll see that that what it does is make people who have very difficult lives and who've had very difficult lives coming to the UK, it makes their lives even more difficult as it bears out on their ability to be joined by their relatives, their partners and their children in the UK. So the first thing you need to look at is to get on top of the vocabulary that's being used in the new system. We have these terms, obviously, most of which we are familiar with, but they're going to be used and deployed in the family reunion rules in a certain sort of way. So we have the term refugee, the term refugee status, humanitarian protection, all of which we are familiar with. And then we have 3 terms at the bottom, which are a little bit different. Refugee permission to stay, temporary refugee permission to stay, and temporary humanitarian permission to stay. So immediately you can see that there's no humanitarian permission to stay. There's only a temporary category for that. And the reason for that is that that humanitarian protection is not conceived of as a route which ordinarily will lead to settlement within 5 years. It's conceived of, even though we know that people who get dispersed into the category of humanitarian protection away from being refugees are those who lack a refugee convention reason, but are still at risk of harm, notwithstanding that fact that it's really about the manner in which they are at risk of harm. Nonetheless, they're considered to be put into this second category of complementary protection, where there isn't the same degree of standards of protection and family reunion rights as those refugees who are classified under Group 1. So humanitarian protection really loses out. And one of the reasons for that may well be that as it's no longer underpinned by the EU's Refugee Qualification Directive, it's now very much a matter of domestic law as to how to provide for complementary protection outside of refugee requirements and obligations. And the opportunity has been seized to downgrade the standards of protection associated with it. So that's the language, that's the vocabulary that we're going to be looking at as we move through the family reunion rules. And you can see here immediately that there are new and extra requirements as the child of a relative with limited leave to enter or remain, where that relative has that leave as a refugee or as a beneficiary of humanitarian protection. And so what this is it's building on, and of course here we're dealing with when you're joining a relative, so not a parent. So the child is joining a relative other than the parent. And in this provision, you'll see that there's a requirement that the applicant will be accommodated and maintained adequately without recourse to public funds. So unless there are exceptional circumstances. So this is a new addition to an already existing rule. This is the bit which is being added on as an extra requirement. And then in terms of what exceptional circumstances are, exceptional circumstances are not defined exhaustively for the purposes of family reunion with a relative. It is that they have no immediate adult family member with them. There's no family other than in the UK that could reasonably be expected to support them. There's an existing genuine family relationship between them and the UK-based relative, and that they're dependent on the UK-based relative. So you're going to have to go through, if you want to lift them out of the requirement that there is adequate maintenance and accommodation, you first of all have to go through those hoops to argue that there are exceptional circumstances. And if you can't do that, then there will be consideration will also be given to Article 8 requirements in terms of whether a refusal in those circumstances would violate the obligations under Article 8. So there are a lot of hoops to go through if you can't have adequate maintenance and accommodation. Note though that the exceptional circumstances are not defined exhaustively, so there may be other matters of exceptionality which you can pray in aid. And then in order to satisfy the rule and bring the person to join their relative. The next provision we're looking at in respect of humanitarian protection is the redefinition of it in the immigration rules. And the point to note here is that a claim for humanitarian protection is a claim that you would face a real risk in your country of origin, not in your country of proposed return. So for those of you that were thinking, well, if my client's transferred for Rwanda because there's an inadmissibility decision raised in respect of the Refugee Convention, and I'm going to argue that they would be at risk and therefore require UK humanitarian protection because of the risks in Rwanda, that's not available to you unless your client is a national of Rwanda. It's your country of origin against which the humanitarian protection claim is to be raised, and not your proposed country of removal or return, if you like. So that definition is important. And then also important is the second qualification to this, which if you make a claim for humanitarian protection, you're going to be deemed to be an asylum applicant. So when you see the term asylum applicant used throughout the revisions made to these provisions of the rules, you need to bear in mind that it embraces also a person who's made a humanitarian protection claim. And then skipping over this bit for the moment, because Ava's already touched on it, a Group 1 refugee will be granted refugee permission for a minimum period of 5 years, and a Group 2 refugee will be granted temporary refugee permission to stay for a minimum period of 30 months, unless exceptional circumstances apply. So there's a lot of haggling that can go on there in terms of representations being made, perhaps as to why the period ought to be longer. The harm, of course, which is done by reducing the period of time from 5 years to 30 months if you're a Group 2 refugee, is that sense of not reaching a place of safety, a place where you have surrogate protection, the anxiety of someone who's had to flee, who've passed persecution and who fears future persecution. They don't necessarily get the degree of comfort. This is that they would get if they were to get 5 years, or indeed if they were to get settlement, having been recognised as a refugee, which used to be the case a while back. So there are real problems with that in terms of its impact. And so exceptional circumstances, if you're a Group 2 refugee, may include, of course, the impact on a person's mental health, their physical health, or other circumstances relating to family members. And you'll see there, as I highlighted a few moments ago, that humanitarian protection is always designed to be, if you like, a Group 2 category, though it's not expressed as that within the immigration rules. You're only ever going to be granted a thing called temporary humanitarian permission to stay, and it will be valid for a period of a minimum period of 30 months. So that's the idea, that humanitarian protection is captured in that way. And so gradually what we're seeing is the degradation of the idea of complementary protection, regardless of your method of travel to the UK. And that itself is a sort of pause for reflection, because it achieves nothing. We may disagree with what Section 12 intends to achieve in the Nationality and Borders Act, but its legislative purpose is clear, and the way in which it's embraced in the immigration rules is clear. Whereas with humanitarian protection, it just seems to be, well, we can, now that we're no longer restrained by a piece of international law or European Union law in the form of the Refugee Qualification Directive, now we can do what we like with complementary protection, and this is what we are going to do. It's better now to start thinking about it as a species solely of domestic law, constrained only by the provisions of the Human Rights Act for the moment, as such as they are in respect of Article 3 protection. As regards a person, family reunion provisions, where the Secretary of State has granted an asylum applicant a refugee status or humanitarian protection, then their dependents may be granted permission to stay, but with the same expiry date and under the same conditions, which is to be granted to the asylum applicant. So you can see everyone is going to be aligned in the provisions made under the new rules. But now the sting in the tail of all of this comes in a whole series of extra conditions which have been bolted on to existing rules for family reunion in order to make it more difficult. The common theme, the outstanding theme of all of these changes is adding requirements, adding hurdles, raising the threshold, making it more onerous, making it more difficult to achieve family reunion rules, family reunification. And so you can see that at the beginning here in the family reunion provision for partner of a refugee with temporary refugee permission. So this is, if you like, a group 2 refugee in the jargon of the Nationality and Borders Act. And what we have here is that a new extra requirement to be met by a person seeking leave to enter or remain as a partner of a person granted temporary refugee permission is added. Both that there are insurmountable obstacles to the couple living anywhere other than in the United Kingdom, and secondly, that their refusal would breach our obligations under Article 8 of the Convention on Human Rights. And so so that sort of language, of course, insurmountable obstacles and a breach of Article 8 is, of course, familiar to practitioners from a range of other contexts in relation to family reunion rules under Appendix FM. But what's interesting here is, of course, there isn't effectively a sort of general class category of family reunion because you're the family member of a partner of a refugee. The extra condition which applies if the person effectively is a group 2 refugee is that this reunion rule has to be satisfied if they're going to be able to live with a person. It may be that it's accepted that they're in a genuine and subsisting relationship, but nonetheless, these extra hurdles are going to have to be demonstrated in evidence. So for those of you who are familiar with the insurmountable obstacles test, you'll appreciate that that introduces an evidentiary requirement effectively to prove to the satisfaction of the Home Office or the first tier tribunal, if it ever gets to that, that the rule is satisfied. And then in respect to family reunion for the child of a refugee, there is a new requirement that if you're over the age of 18, there must now be exceptional circumstances. So that, and the way in which that's phrased, you can see here on this slide, that they are dependent on the financial and emotional support of one or both of their parents in the country of origin. So that's 2 elements to that, financial and emotional. The parents or that they depend on are coming to the UK. They're obviously a series of criteria that we're well familiar with, that they don't lead an independent life and have no other relatives to provide a means of support. But also that they cannot access support or employment in the country in which they're living and would therefore likely become destitute if left on their own. That's an incredibly high hurdle to show, that they could not access support or employment in the country in which they're living, and therefore would likely become destitute. That's going to be extremely difficult. It obviously reminds us all, in fact, of the tightening of the aperture in the adult dependent relative rule, through which you had to pass in order to satisfy that rule, which happened some time ago. But you can see here that the bar is really being raised extremely high. And if the decision maker is not satisfied that there are exceptional circumstances, then you have a sort of Article 8 long stop that you can try and say, but nonetheless, the requirements of Article 8 are such that refusal of entry would be disproportionate. So again, it's really frustrating, the idea of family reunion, where the child happens to have reached the age of majority and turned 18. And in addition, so that's a general rule which is introduced, but for those with temporary refugee permission, an additional hurdle is introduced for family reunion for their for children, and that is that there are insurmountable obstacles to a parent and child living together anywhere other than in the UK, and that refusal would amount to a breach of Article 8 of the Human Rights Convention. So obviously here the focus is on a return to a third country, because a person who's a refugee obviously can't access protection in the country of their nationality or habitual residence. And so what you're seeing here is again, effectively a raising of the bar. You have to, I mean, it may be that there is no obvious automatic third country in which a person would be able to remain, but that question may well be tested and contested by the Secretary of State in seeking to refuse family reunion to the child of a refugee, where that refugee is a Group 2 refugee with temporary refugee protection. So so that makes it introduces an additional hurdle and emphasizes, if you like, the nature of the punishment for not satisfying the Group 1 criteria under Section 12. Because after all, what you're doing is you're splitting up families in operating this rule to the detriment of family reunion. And we should be very clear about that the whole tenor of the immigration rules is in that direction. Then there are rules which sort of reflect that general approach in terms of family reunion rights for a person with humanitarian protection. When we come to look at this provision, you'll see that there's a new extra requirement which has been bolted on for a partner, which mirrors the approach taken to those with temporary refugee status, Group 2 refugees. Again, that there's an insurmountable obstacle test to the couple living anywhere other than the UK, and that refusal would breach Article 8 of the Human Rights Convention. So again, testing this point about whether there's another country to go to. It doesn't say country of your another country of your nationality in cases of multiple nationality, really in essence likely to be looked at in a country to which you would be admitted with the ability to reside there, not just to stay there on a temporary basis. That sort of issue is likely to become alive again when looking at this rule, in cases where the Home Office think they've spotted something either in the initial temporary refugee application or humanitarian application of the principal person, or in the application made by the partner seeking to join them, where the Home Office spots something that might indicate that there might be a third country to which the person could go. So again, that's something, a sort of retrograde step. And then again, with as regards the child of a person with humanitarian protection, you can see again that there are provisions for if the child, a new requirement in respect of the child being if they're over 18 and there are exceptional circumstances, then that introduction of the need to satisfy the exceptional circumstances requirement is introduced, and also separately that it should be that there are insurmountable obstacles to the child living anywhere, not the couple, sorry, living anywhere else other than in the UK, and that refusal of leave would breach Article 8. So again, the bar is being raised in the context of family reunion under the humanitarian protection route. And you can see there the exceptional circumstances test follows the same formula as was used in the exceptional circumstances test for a child that reached the age of 18, where that child is a child of a person with temporary refugee protection. So again, really quite a high bar that you would not be able to access support or employment in the country in which you're living and would likely to become destitute. It's the sort of thing that's going to be very difficult to prove in practice. And then a sort of sting in the tail, always remember that the rules for achieving settlement are now hived off from the main body of the immigration rules into one of those endless and ever-growing list of appendices that follow on at the end. And what we have here in Appendix Settlement Protection is a shift, a substantial shift in policy, which is that only those who are granted refugee status, as regards those who are those people who made asylum applications before the 28th of June 2022 still have access to settlement if they were granted refugee status or humanitarian protection. But as it regards the cohort of people who were granted protection on or after the 28th of June, then it's a more limited class of people, because you have to have Group 1 refugee status, refugee permission to stay, if you applied on or after the 28th of June, to have access to the settlement rule after 5 years. For those that applied on or after the 28th of June for protection and were subsequently granted temporary refugee permission to stay or temporary humanitarian permission to stay, they are not eligible for settlement under the 5-year route now. That's not available to them. So Group 2 refugees are punished because of their mode of arrival, and those with humanitarian protection are punished because they can do that effectively, and they have done that because they're not constrained by the EU Refugee Qualification Directive as regards humanitarian protection. Of course, there is a 10-year route generally to settlement, which is found, of course, elsewhere in the immigration rules. But again, it increases the idea that the people who come here and to the UK, to whom the UK affords a measure of protection, whether through temporary refugee protection or through temporary humanitarian protection, they will still have a certain anxiety that there will be an active review at the end of a 30-month period after 2.5 years, and that they may no longer enjoy protection. In practice, leave may be rolled over after 30 months on a renewed application, but it's not guaranteed. And even if it is, turns out not to be a deep dive into whether or not there are still protection needs after 30 months. One has to consider the anxiety it will cause to the person enjoying that temporary refugee protection or temporary humanitarian protection, and the distress it will cause, and in many cases, the impact on mental health that it will cause to people. So having received a measure of temporary protection, not only will you still be leading essentially a life of anxiety and an increased degree of precariousness, but also you may face real obstacles in achieving family reunion with your partners and with your children as a result of these changes. And so there's nothing really much good to be said about them at all. They're going to make lives immeasurably more difficult, and they're going to make our task in gathering evidence and marshalling submissions on behalf of our clients more difficult as well. So there's nothing to be optimistic about, but those are the provisions, I'm afraid, and that's what we're going to have to contend with. We do have some time for questions now, both on the material which Ava covered and also the material which I covered, and I hope that there are some questions. I'm just going to look at the chat. Ava, I don't know if you've had a chance to read the questions while I've been
so there are actually quite a lot of questions in the Q&A box, which I think will be very useful to discuss. Many of them relate to the family reunion provisions. Maybe while you are looking at these, I can start with one that is more in relation to my subject. And that question is, when will applicants be told that they are a Group 1 or Group 2 refugee? Will it be when they are granted status And will they be able to challenge the designation by JR? So I think, and Adrian obviously come in, but I think that must be right, that people are told when they're granted refugee status, whether they're granted or where they're accepted as a group 1 or a group 2 refugee. And absolutely the way to challenge it will be by way of judicial review.
Yes, I mean, this classification, which obviously has huge impact on family reunion rules and access to settlement, and potentially down the line could indeed lead to a restriction on no recourse grounds further on, should be challenged if it's going to have a material impact. And of course, one might argue it will have a material impact on any group 2 refugee, because if you're put on a 10-year path to settlement, that's an impact on your life. I mean, it's so in terms of your ability to achieve that. So there may be good arguments that we can deploy on behalf of clients routinely, but obviously those arguments will be much bolstered if there's a particular prejudice to family reunion. Then that's going to animate any judicial review challenge, because it will enable you to draw in Article 8 and also best interests if you've got minor children, and if you've got adult children, the continuing nature of family life on Kugas type criteria. So that's going to be important. And maybe we have to get used to that there is this whole series of collateral challenges which may emerge where people are wrongly classified. And then as Ava's presentation highlighted, that the test for classification under section 12, the number of judgments being raised about, for example, whether you've come directly from a country, all of those points will effectively have been decided against you when the Secretary of State puts you into group 2, even if there isn't any express reasoning on the face of the letter telling you in which category you've been classified. And so exploring how we get the judgments of the Secretary of State that they've reached and how we challenge those is going to be very important in terms of fighting for the idea that everybody ought to be in group 1 effectively, that they ought to be in the class of people who get the gold standard of protection, such as it is, under the new rules. There are other questions in the chat. I'll have a go at one while Ava prepares another one. June has asked, can I ask if we think the new family reunion provisions will apply to anyone who already holds HP, they don't apply if you already have HP and you applied for protection before the 28th of June, the old provisions apply to you. But if you apply for it on or after the 28th of June, then the new provisions apply to you. So there's a big shift in policy on that date. So Ava, I don't know if you've had a chance to look at another one while I read the next question down at all.
There are quite a lot. Actually, there are quite a lot of good ones, more for debate on the family reunion provisions.
Okay, let me just have a quick look and see where.
Yeah. So
if anonymous at 104 says, would the provisions of the Act be applicable in old asylum cases who've already been dismissed negatively via the tribunal, but who are seeking to make a fresh claim? So a fresh claim will only be considered an asylum application under the rules as they're drafted in the regime, in circumstances where it's recognised as a fresh claim. So you'll have to leap over that test in paragraph 353, and the date on which you do that, either by the consent of the Secretary of State or because you achieve the time in which you do that, you achieve a decision in any challenge to an imposition of a 353 decision in the tribunal, then in the upper tribunal, then you'll be able to have an asylum application, not before. So it's just because you've made further representations, that's not necessarily a trigger that there is a fresh claim until it's recognised as such.
But I think it will be, and Adrian, correct me if I'm wrong, but I think it will be if there's a fresh claim. The operative date is probably the date at which it's accepted as a fresh claim. And if that's after the 28th of June,
Well, that raises an interesting point, doesn't it?
Yeah, it does.
When is it a fresh claim? And that may well be a point in the from the date of recognition or the date of application. And the earlier date, the date of application, would obviously be the one that you would try and strive from. It has always been a fresh claim, because of course the decision on whether or not it's a fresh claim obviously arises after leave has been refused in the operation of decision on further representations, in terms of the way in which paragraph 353 is structured. So you would go for, we would try and contend for the date of application in order to, because that would be the earlier point in time rather than the date of recognition. There's a comment from Tarek, which I think is a comment rather than a question, that understandably, if this wasn't enough, the new Bill of Rights will also strip away the checks and balances in ECHR. I mean, just while we're touching on this subject, obviously we're all going to have to be doing a lot of work on how the Bill of Rights, if it makes its way, as it makes its way through Parliament and after enactment, how it impacts upon this area. Obviously, Article 8 in the context of immigration is being singled out for particular attention in the Bill of Rights, and not to our advantage again. So we will have to been doing some work on that, and also in respect of interim measures under Rule 39, obviously very topical in the light of events in relation to the Rwanda chartered flight, that there is a specific provision to deny the status of law to Rule 39 interim measures in our domestic legal order contained on the face of the Bill of Rights. So that's another alteration to the landscape for us as immigration practitioners. Of course, we're all aware that Rule 39s have often been used in this context of UK immigration practice, and that's going to change things as well in relation to those that risk refoulement either to their countries in removal and deportation, or onward refoulement if they're going to countries on the basis that their asylum claims have been judged inadmissible in this jurisdiction because there's a safe third country to which they can go.
Yeah, there's another question about the date that seems to be a major concern, which makes sense because it's so difficult to advise on. Will a decision after the 28th of June conferring Group 1 or Group 2 apply to asylum claims and appeals pending at present? So again, the operative date is when the asylum claim is first made.
Yes. Yeah.
So if the asylum claim is made before the 28th of June, then it's fine. There's no distinction between Group 1 and Group 2 refugees. And I set this out on one of my first slides, if you just go to that, and it's also confirmed in the rules. So you can find that.
Yeah, and I'm just picking up another question. There's a question, I think it might be from Natalia, that would there be any basis of challenge on the basis that Group 2 would be in breach of the Refugee Convention? And this too is a very interesting question, because the Refugee Convention contains standards of protection, as we know. We're always familiar dealing with Article 1, and we're all very familiar with Articles 31 and 33 of the Convention in terms of penalties and the barrier on refoulement. But in the question of the standards of protection in the Convention, in terms of access to social welfare and authorization to work and so on, it's worth having a look to see what's being done and what restrictions are being imposed, and measuring them against the standards of protection in the Convention to see if there's any delinquency in terms of the outcome. At the moment, in terms of the way in which the rules are drafted, in the immigration rules coming in on the 28th, the main prejudice is to settlement and to family reunion. And of course, family reunion isn't provided for directly in the text of the Refugee Convention itself, unfortunately, as opposed to the surrounding work done around the convention. So it's going to be difficult, but there are standards of protection in the convention in the range of in terms of the way in which the lives of refugees are there. There are different standards comparing, sometimes comparing the level of protection afforded to aliens similarly situated, sometimes to nationals of the host country, and of course the different levels of attachment, whether you're staying in, and so on and so forth, or lawfully staying in. There are different levels of attachment as well. So we'd have to do some sort of audit of the immigration rules against the standards of protection in the convention in order to come out with an answer to that. But on the face of it, if it's just about prejudice to family reunion and access to settlement, it may be difficult to argue that as currently organised, that Group 2 status infringes the Refugee Convention directly, except potentially, I suppose, in terms of access under Article 34 to a durable solution in terms of acquiring the nationality of the host state. If you're shutting people out from access to settlement, you're shutting them out from being able to apply for naturalisation under Section 6 of the British Nationality Act. So that might make a difference in that context. Ava, I don't know if we've got time for one more or not. I'm conscious of, I'm just looking at the clock. We're finishing at 1:30 today.
Yes, and I'm just answering another one by typing it.
Okay.
But yeah.
And there's I think there's a question in relation to the exceptional circumstances test. I think it's a non-exhaustive list, the exceptional circumstances test, wherever it occurs in the rules. So they're examples, they're not cumulative. And it's very, unsurprisingly, the immigration rules are not terribly well drafted, but there is an include at the top of them. And that will give us a steer, although it's non-exhaustive, it gives you a steer to the sort of factors which may not be specified, but which may also be included, things of that order. And so, yes, the question does make sense, but it's also one in which we can take comfort from the fact that it's not a cumulative test and it's not an exhaustive test. And it's up to us to come up with reasons as to why exceptional circumstances are found on the facts of an individual case. There's a question, just finally, if we've got time, what would be the impact on statelessness applications? There won't be an impact on Part 14 on the statelessness provisions of the immigration rules because they're concerned with a different form of leave unless they adjust those provisions and access to that, which of course is statelessness leave is conferred on an in-country basis, not at port on arrival, but solely on an in-country basis. Then it won't have an impact on people applying under that rate. So it's 1:29. I think we probably have to wrap up. I'm sorry if there are unanswered questions. There's a lot to think about and a lot to do. I mean, the main takeaway from today is that it is pretty much a wholly negative picture in terms of refugee family reunion and in terms of access to settlement for those who are Group 2 or on humanitarian protection routes, that we're going to have to rethink in terms of satisfying the criteria for exceptionality and also the additional standard thresholds and tests which are put in, sort of evidence which is, needs to be gathered to make a successful application. We're going to have to explore in a little bit more detail whether family life can take place in third countries, as well as just thinking about the country of return as well. So a lot for us to think about. Maybe we may well come back on a seminar when we've had 6 months experience in dealing with this, and we can share among ourselves and maybe more of a collaborative exercise with people chipping in terms of how they're finding it. And we may need to review tactics in terms of how to make successful applications and how to bring successful appeals against refusals in the tribunal. But thank you all very much for attending today. We hope to see you all soon in our next webinars, and do let us know how you get on. Thank you very much.
Thank you.